Good evening, everyone, and thank you so much for joining us tonight. I think you're going to find the presentation worthwhile and thought-provoking. I was with Kathleen this afternoon at Southwest, and we had two different sessions with various providers, and I think a lot of good conversations started there, so hopefully it'll continue tonight. So it's my pleasure to introduce to you all Kathleen Hessler, a nurse attorney. Notice it's nurse first, then attorney. She is the Director of Compliance, Risk, and Ethics at Simeone Healthcare Consultants, which is actually located in Hamden, Connecticut. However, she comes all the way from Albuquerque, New Mexico, flew in yesterday, so we appreciate this. She goes all over the country. She has 30-plus years of combined nursing, legal, and consulting experience in healthcare. She began her career, as I said, as an RN. After earning her law degree, she served in corporate counsel and compliance roles for acute care, long-term care, and post-acute healthcare organizations. She served 11 years in her own law firm, representing various providers and consulting on regulatory compliance and operations, regulatory appeals and mediations, and developing, maintaining compliance and quality programs. She is a frequent national speaker. We are fortunate that Diane Major brought her name to our attention after she heard her at a home health and hospice conference up in Maine. She's here tonight to give us her insights on legal and ethical issues around palliative care. Please help me to welcome Kathleen Hessler.
Thank you very much. Thank you very much. And thank you for being here. It's a beautiful fall evening. I know everyone could be other places. So I'm going to start with the title of this talk, Respecting the Age of Patient Choice, Advanced Directives, and End-of-Life Care. So one of my first questions is, how many in the audience actually have advanced directives, living will, or an appointed agent for decision-making, or both? Okay, great. I usually start out by asking that question, and I'm amazed. I've been doing this for many years, and I'm amazed still at how many people don't yet have them. And we'll be talking tonight about some of the reasons why it's so important to have these documents. At a minimum, to have talked to your loved ones, your family members, or some special friend who you would want to make those decisions on your behalf. But if it's not a relative, as you'll find out under Connecticut law, unless you have them appointed in writing as an agent, they won't be able to make those decisions for you without a court order. Now, looks like I went from the beginning to the end. So let me go back home. That was quick. Okay, so as Joyce mentioned, I work for Simeone Healthcare Consultants. They are a consulting firm that has been in business since 1966, the year that Medicare came out with the home health benefit. The Simeone brothers, there still are three Simeone brothers, and they are all CPAs, and they started providing cost report services and financial planning services for home health companies. And as the Medicare benefit improved, increased, more beneficiaries for home health and hospice, the company has taken on several different models over 50 years. But we are exclusively dedicated to the home health and hospice space, from financial planning, clinical operations. We place interim managers. We do executive recruiting. They contacted me about 6 years ago and asked if I would be willing to come on as their National Director of Compliance and Risk. So I have been with them, although I'm based in New Mexico. So this is just another slide of the services Simeone offers. But as I drove down here from the airport last night, I waved to the exit, Hamden, Whitney Avenue exit. So this session is for educational purposes and should not be construed as legal advice. And with Simeon, even though I have an active law license in New Mexico, I do not practice law for Simeon. I am acting as a consultant. And I hold an RN license in Washington State, where I practiced nursing for many years. And I also have spent a lot of time on ethics committees and have a couple certifications in healthcare ethics. So we're going to talk about bioethics and a little bit on corporate ethics, but mostly bioethics tonight, and the legal and ethical differences or conflicts that you all deal with in today's healthcare world, or if you're students, that you will be dealing with. How many of you are nursing students or nursing graduate students? Okay. And how many of you, the rest of you, are you clinicians? Doctors? Oh, okay, RN graduate students, so you're, okay, nurses. And we have a couple doctors in here? Okay. So the overview here is, legal and ethical issues in clinical matters present challenges. And what is legal may not always be perceived as ethical, depending on your values, the values of your community, your organization, and your personal spiritual beliefs. So we'll talk about autonomy, patient choices, and advanced directives, and how they present ethical and legal challenges in today's world of evolving technology, medical marijuana, and these end-of-life choices. Now, Connecticut doesn't have aid in dying laws, but there are 6 states and District of Columbia where that's legal. And Hawaii, it'll be legal, lethal dose for patients who choose that. That'll be legal in Hawaii starting January 1st. So we're also going to talk about the importance of creating an open and ethical culture in your practices or the organizations or hospitals, clinics where you work, to assist in having these conversations with other employees, with patients, and with families. So these are the objectives. State the difference between an ethical analysis and a legal review. Identify points in history that shaped the bioethical principle of autonomy. State at least 2 benefits of executing advanced directives. Define and differentiate between competency and capacity. And identify practices to assist clinicians in dealing with ethical choices or ethical issues surrounding patient choices. So I usually like to start with defining the law. What is the law? Law is based on statutes, federal statutes and state statutes, regulatory rules, and common law, which is case law. Judicial precedent by appealing certain cases, that becomes case law and actually becomes actual law. And law, if you break the law, there's usually punishment and accountability, which is different than ethics. Sometimes there are ethical codes of conduct that will cause repercussions, but when you break the law, the idea is, to take accountability and punishment. Now, I threw in corporate integrity agreements here because this is, does everyone know what that is? Corporate integrity agreement? It's actually an agreement with a healthcare provider, whether you're a physician, home health, hospice, hospital, if you've been alleged to have committed fraud or have overpayments where you've inappropriately billed, rather than exclude you from the Medicare program, program, the government will put you on a monitoring program for 5 years. So many providers do consider this a form of punishment, and it certainly is a form of accountability. These are the types of cases where you're reading in the news where it says healthcare fraud, company pays $15 million back. So I threw that in because that is, that is showing you that when you break the law, there are repercussions in healthcare providers. So ethics is a word that comes from the Greek word ethos, which means custom or character. It's really about doing right or wrong. What is ethical? Most people think of something that's right. That it's ethical, it's okay to do, it's a good thing to do, as opposed to unethical. It's not right. So if you think about it, most professions these days are governed by a code of ethics. So we have lawyers, believe it or not, have a code of ethics. The American Bar Association model rules of professional conduct. And of course, the American Nurses Association Code of Conduct, American Medical Association. And I don't know how many of you work in hospitals or clinics that actually have a code of conduct or a code of ethics. How many of you have, during orientation, are you given a code of ethics? Okay, so you're seeing more. When I first started, my career in nursing, I don't remember that, code of ethics in the organization I worked, but we are seeing more and more companies have you sign a code of ethics when you sign an employee handbook acknowledgement. So who decides? Ethical principles or judgments are closely related to moral judgments or principles. And morals are basically a set of values. So ethics, again, think about your own ethics, how you personally feel about certain things, or your family beliefs, and how different they may be from your neighbor or a relative or someone you work with. And, again, values differ in people, cultures, communities. So an example would be our US democracy. As a society, we value democracy. We value the independence, person's right to vote. This is a value that we as a society hold. So if you think of it in that light, we'll drill down a little bit. So, a value, again, is something that it's a quality or standard that most people would say is desirable and important. So we have many types of values, social programs, different people have different spiritual beliefs, religious beliefs. Again, the legal issues, economic. Some people spend every paycheck, they want to live today. That's their value. Other people save, they're more frugal. Again, that's a value that people hold. Environmental values. Corporations. Again, I've worked with many different clients throughout my career, mom and pop companies to big, large, national healthcare organizations. And it is amazing to me the differences in what you call corporate culture or organizational culture. And truly, the people at the top of an organization do dictate that culture that permeates down throughout the organization. So it's, those values are, do permeate. So if you set the tone to do the right thing at the top, normally you will see that permeating down to the different levels. And then, of course, as a society, in healthcare, we value autonomy, the principle of autonomy, the principle of independence, the right to make our own choices about our healthcare, the right to refuse certain treatments for healthcare. and now even, let's see, where was I there? So, and now, of course, I think Connecticut has legalized medical marijuana, correct? You don't have, as I mentioned earlier, you don't have End-of-Life Options Act that allows a person to, a physician to certify for a legal dose or order a legal dose, but other states do, and it's something to be aware of. But these are things that, these areas are creating conflict, not only for healthcare providers and employment issues, but in practitioners taking care of patients, depending on your personal values, for instance, on medical marijuana. You know, think about, do you let that, if you've had the experience of working with patients with medical marijuana, have you let that, your personal views influence how you treat someone who chooses that for, you know, their treatment? So in healthcare bioethics, there are basically, you know, there are several ethical principles, but these are some of the most common. The respect, again, for the individual autonomy, the right to make decisions, which goes with informed consent. So we're going to talk a little bit later about consent and informed consent and how that, you know, is part of the bigger picture of autonomy and independence. And non-malfeasance, do no harm to a patient. And beneficence is do good, not only do no harm, but what can you do that's good for this patient to bring benefit to this patient. And then the distribution of justice, the bioethical or ethical principle of the distribution of healthcare. Now, I remember I graduated from nursing school quite a while ago, but even so, when I graduated from nursing school, I don't remember there being a scarcity of resources. I didn't know, I thought everybody got health care and everybody, who needed it got what they needed. And my first job, it was at the University of Minnesota in a cancer research center. And then I moved to Seattle and worked at the Northwest Kidney Center with peritoneal dialysis patients. And I was writing some articles for the newspaper, the Northwest Kidney Center paper, and I started researching when dialysis first came out, how scarce the dialysis was, the dialysis machines. So in Seattle, where some of the first dialysis patients were dialyzed, they actually had panels. They called them community panels where people decided, which patients were going to get dialysis. And what were they, parents, what kind of jobs did they have? They actually went through an analysis because of the scarcity of the dialysis machines. So that was a really new piece of information for me, and I believe that was in the 60s that they were doing that, the early 1960s, but don't quote me on that because I don't remember my exact facts. But the point is, I think today we are seeing, a scarcity of resources in a sense of access to health care, disparity of health care, access, just the different benefit plans. We see more and more Medicare beneficiaries, and everybody's wondering if there's going to be enough money in the Medicare program. Medicaid, every state has their own Medicaid programs. Some states have multiple programs, and patients can be, or clients can be on multiple programs at the same time. So we're seeing more states start auditing those Medicare programs. So there's this distribution that is uneven for many reasons, which that's a whole nother day lecture, I think, and I won't get into that. But so, that's just an overview kind of the law and of the ethics, the basic difference of law and ethics. So if you know something's legal, and the majority of people, based on your values, believe it's ethical, you really don't have a conflict, right? There's no conflict. Or if something's illegal, and most people believe it's unethical, regardless of where you fall in other major things, you still don't have a conflict. But when you start seeing conflicts is where something is actually legal, but depending on your values, it may be unethical in your mind or your family's mind, your community, whatever. So if you haven't looked at the next slide, what are some examples of this legal versus ethical conflicts that we see and we hear about every day in the papers, on the news? Anyone?
I think about in home care and hospice, how many patients or their families have said to us as a hospice nurse, when it gets to the end, if they're really uncomfortable, my family member, how much morphine would it take to, end their life or to end my own life? And that's a legal issue because it's illegal, and it's an ethical issue because we don't want to give them that kind of advice, but we know they want to know, so it's that dilemma.
Okay. So it's that it's illegal to euthanize, it's illegal to over-medicate someone to the point of death, if that's your intent. But the ethical issue is pain management, and or someone you love wants their suffering to end or is ready to end. So that is what we're going to get to the basics of here. But overall, the real clear things we're seeing every day, this is the last thing there, the end of life, informed consent, autonomy, withdrawing, withholding treatment that Diana was talking about. But again, the Affordable Care Act, the birth control issue, abortion, gun control, medical marijuana, gay rights, gay marriage, the end of life acts in some states. So all of these things, there are legal sanctions, legal permissions, if you will, for many of these things. But again, depending on your values, you may fall on the side of unethical. And maybe one of these or both of these or, all of these. And so, some things that are legal, you may say, oh no, I believe in that. I believe in medical marijuana, there's no problem. But you might not believe in gun control. So you see where some of this stuff can get very complicated when you're the practitioner dealing with families and patients, on these end-of-life issues. So I'm going to go briefly through the history of bioethics and where we got to where we are today in autonomy. So in the early 1900s, the idea of consent, giving consent to what happens to our bodies, goes way back to the early 1900s in America. There were four main cases during 1905 to 1914 that where this one, the example I have up here was a surgery where a woman had consented to be examined under ether, I think it was at the time, and but she specifically said she did not want anything removed. I think it was, can't remember if it was an ulcer or fibroids. No, regardless, the doctor went in there and removed I think it was a tumor, I can't remember now what it was, but the judge called it a battery. And there were 3 other cases during this decade that the judge determined it was a battery, and that the patient has a right to consent to what is done with their body, and the practitioner has to respect that. There are some details in this case that the hospital ended up winning that case, but not withstanding the case law that was made about, that this is a battery and that we must get consent to perform procedures on patients. And then pre and post World War II, in our country, the U.S. Public Health Service had a study, the Tuskegee study. How many of you are familiar with that? It was a horrific study. And during this time, this was, the researchers were studying the course of syphilis in African American men, and they were not telling them that what they were doing. They were giving them free meals and taking their blood, but they weren't informing them on the details of the study or what it was exactly for. And they had a group of healthy subjects and then, a group of men who had syphilis. And in the 1940s, when penicillin came on the market and was in fact effective against syphilis, these men still were not treated. And they continued to be monitored up until 1972 on this experiment. And, if you think about it, this was the time during World War II where these egregious, horrific experiments were being performed by the Nazis on prisoners of war. And yet, even after the war, in our country, we had experiments on human beings that we were not providing informed consent to, and we were experimenting on. So these abuses in human experimentation were exposed in the mid-1960s and 70s, and I'm sure you have probably several classes on healthcare ethics or things that you can choose from the university. But the Belmont Report of 1979 came out, which exposed abuses of subjects involved in research. And so as a result of that, the concept of informed consent really evolved and especially for research subjects, human research subjects, but even for other forms of treatment, informed consent became the norm, and written informed consent. Now, when you are working with patients who are admitted, come to your clinic or come to the hospital, there's an implied, they usually sign a general consent for having their blood pressure taken, venipunctures, different things that are done. But I still think it's so important as practitioners to speak to that patient and tell them what you're doing and ask them, their permission to do this, or listen to them if they say no as you explain something. And so that's, where informed consent kind of gave birth, as a result of these horrific things that happened. And then we kind of the tides turned a little bit in the 1970s as our technology started increasing the opportunity to live longer and people to be put on life support, ventilators, artificial feeding tubes, TPN. So, that created a whole nother set of issues on does a patient have the right to refuse treatment? Not just consenting for treatment, but what about saying no to treatment that can be life-sustaining? So the landmark case in 1976 was the Karen Ann Quinlan case. Is everyone familiar with that? 21-year-old went to a party, took Valium alcohol, ended up in a persistent vegetative state, went through the New Jersey court system, New Jersey Supreme Court. The parents wanted to take Karen off the ventilator because she was on a ventilator. They finally got permission when the New Jersey Supreme Court ruled it was okay. They took her off, and lo and behold, she lived another 9 years. She did have a feeding tube, and the parents never contested that, and she lived for 9 years with a feeding tube. So during that period of our history, 1976 to 1988, by one count, there were about 54 reported decisions involving the right to refuse life-sustaining treatment. And the next landmark case was the Cruzan case, Nancy Cruzan, in the 1980s, and that went up and down the Missouri courts, and then to the US Supreme Court. And this was another woman in her 20s who was in a car crash, and I think was found face down, had brain damage. She didn't need a ventilator, but she had a feeding tube. So her parents, fought to have that feeding tube removed, wanted her, they said that it was her wish that she would not have wanted to live this long. But they couldn't find any evidence to the contrary, that stated that. And then the Supreme Court said that, yes, a person has a right to refuse life-sustaining or extraordinary treatment if there is clear and convincing evidence that they would have wanted that. And the Cruzan family went back and did find some friends and people who said that they had conversations with Nancy or that she would not have wanted to live. So they were allowed finally in the 1990 to withdraw the feeding tube. So as a result of this case, the Cruzan case was the landmark case that really, I think, moved Congress, really got Congress to act. Congress said, the courts basically said, the courts are not the places to make these decisions. Look at all these cases that we've had on end-of-life extraordinary treatment. This is not where we should be making these decisions. These should be made by individuals, and individuals should be able to think about this and make decisions in advance. They should have the right to refuse treatment. If they're in a persistent vegetative state or in a coma, their family members should be able to make healthcare decisions. So Congress passed the Federal Patient Self-Determination Act in 1991, and as a result of that act, which requires all healthcare providers who receive federal funds to ask patients if they have advance directives and to provide information on advance directives to patients. And I think just about every state in the country in the early 1990s passed legislation. Some states call it advance directives. Connecticut is, I think yours is actually called end of life. I just had it. I was looking at it the other day. It took me a while to find the Connecticut law because of the title. Most states many of them are called advance directive laws. New Mexico is one of 6 or more states that has Uniform Healthcare Decision Act, which is actually more liberal than the Connecticut law. But basically, these laws allow people to make their decisions in advance, gives protection to physicians who follow a patient's duly executed living will and or work with the agent for healthcare decision-making. It gives providers immunity if they follow the wishes. Now, I throw this other case in here because even after the Federal Patient Self-Determination Act was passed and after most of the states passed advance directive laws, we still had this Terry Schiavo case. This went up and down the court system. This woman collapsed and fell into a coma. I think she had a history of anorexia. She had some heart problems. Her husband ended up taking care of her for quite a while. She was in a persistent vegetative state. He actually was ready to remove her feeding tube, and the parents went to court, and it went up and down the court system. This was in Florida. But in 2005, the feeding tube was removed and she died. But this case to me underscores that even with the advance directive laws and people's right to make these living wills and appoint agents in advance, many people still don't do it. The other thing that struck me is these 3 landmark cases, what do they all have in common? Pardon? Young women that you would never think would need an advance directive. So, I mean, that underscores, one of the reasons that you want to do that. So simply put, what is an advance directive? It's a written document, a directive by you in the form of, it can be one document, but the living will portion of the document is stating what you would want in the event that you become comatose or in a persistent vegetative state and there's no hope of recovery, or it's an irreversible condition for which the doctor believes you would otherwise die. If it's a persistent vegetative state in Connecticut law, the doctor is required to consult with a neurologist as well. But the living will, you can state that you would not want extraordinary measures, you would not want a ventilator, you would not want a feeding tube. There are certain things, some people do write more details in there. And it can get more complicated, but the main thing is, the main intent originally of these laws was the extraordinary measures such as ventilator or feeding tubes. And then the other document is a person can name an agent, also called healthcare representative. That's the Connecticut terminology you use. And surrogate, healthcare proxy are other terms people use, but you can name an agent to make those decisions on your behalf. Hopefully it would be someone that you have talked to about and asked if they would, should this happen to you. I mean, you're not required to. If you do an advance directive and say, I'm gonna name my sister in Minnesota, but oh yeah, I'm gonna call her next week, and you never call her, but then you end up in a persistent vegetative state, that person would still be your appointed agent. But the ideal is for you to talk to that person who you want to be your agent, so they know what you would want. So under state law, again, I already talked about this, some states use different titles for the advance directive, but most states will have a list of people. So let's say you don't have an advance directive, and you go home tonight and you don't make it home tonight because you're in a car accident. If you have maybe you don't have a living will, but at least you've named an agent, that's good. If you didn't name an agent, you don't have an advance directive. In Connecticut, your spouse would be your decision maker. If you don't have a spouse, it would be adult child. If you don't have an adult child, then it's your parent, and then grandparent, next of kin. Now, New Mexico allows someone who, like a friend, or someone who knew me at church, if I have no one else in my life, no relative, next of kin, New Mexico will allow someone to make that decision. So I was director of risk management at a hospital in Santa Fe for 3 years and worked extensively with physicians. I was often called to the bedside with physicians and patients. These acute crisis where they didn't have an agent, or there was nobody. They were alone. And so, we didn't have to go to court. In your state, you would have to go to court to get someone appointed to be that medical power of attorney or the healthcare representative if you don't have a next of kin and you don't have an agent. But in some states, we didn't have to do that. And let me tell you, that's another reason to have an agent, name an agent, because it's very expensive and it's time consuming to do. And you don't want to get in that situation. If the other situation, I've seen it happen over the years in working with nursing facilities and in the hospital, was if you have adult children, there's no spouse, but the patient or resident of a nursing home is incapacitated, then there might be more than one adult child and they don't get along. So one will go to court to get appointed as the medical power of attorney. So then you end up with a very expensive situation for the family. So in Connecticut, this is just kind of a review of your laws, but down here, the next of kin. So that's how your statute reads in Connecticut. So if there's no guardian for a patient and you don't have a healthcare representative, the patient didn't appoint one, then the spouse, the adult son or daughter, parent, adult brother or sister or grandparent. So that's where it stops for Connecticut. Advanced directives in Connecticut, if you're here in Connecticut and you see patients from New York or any other state and they have advanced directives from other states, those are valid as long as they aren't contrary to Connecticut law. But if in that state, if they have an appointed agent and they otherwise followed the state law, and it's not for you to question whether that is valid was that valid when they executed it in New York or Florida? You don't have to make that decision. If someone contested it or protested it, then that would be a different issue. But as long as it's an executed advance directive, then you don't have to make the decision on whether it's valid or not. You follow it. And the same with another country. So whether it's, in English and Spanish, from another country, from here, if it's a valid healthcare directive. You do have to be 18 years old to execute an advance directive, and a healthcare provider, as I said earlier, can rely on that, and there's immunity for following, healthcare directives. Now, this came up in our session this afternoon. An advance directive the intent of that is to state your wishes in the event you are incapacitated, either in a comatose or persistent vegetative state, or otherwise incapacitated to make your decisions. But it also means you have an irreversible condition, or terminal. In Connecticut, the word is terminal, and you have your death would result within a short period of time, or you're in a persistent vegetative state. So if you're going into surgery and you code in surgery and you have an advance directive that says you don't want extraordinary measures, that's not applicable there, because if you went into surgery and you don't otherwise meet these other conditions, but it's really, do you have this terminal illness that you're otherwise going to die and you're comatose or unable to make your decisions or incapacitated? But the issue came up today about someone who maybe does have an advance directive and doesn't want extraordinary measures, but they go into surgery, and what if they code? Well, I think what you'll find that most physicians when they have a patient like that who maybe does have some sort of long-term chronic condition, but they will, specifically say DNR does not apply for the surgery or during surgery, or if they have a DNR. The advanced directives, the ones, many of them I see don't specifically say do not resuscitate. They're really about, do you want, that's included as an order normally in their charts, and some people will say, I don't want to, I want a DNR, and I don't want feeding tubes, and I want this or that. So you may see it all in there, but again, you'll have to, if those situations arise, just work with the doctors, and the doctors should be writing orders on that. And then the other definitions, people sometimes get confused and ask about the powers of attorney for finances. If someone has a power of attorney to handle their finances, that is generally a different document. The healthcare directives, living will and agent, is really strictly for healthcare. Now, in Connecticut, you do have a section that you can elect a conservator to make decisions about your organ donation or burial. I think it's or burial too. But generally, powers of attorney for healthcare decision-making, agents for healthcare decision-making, and powers of attorney for finances usually expire on death, and then the executor of your estate takes over. And they're not always the same. And even in families, you may find this happens quite a bit, where one of your patients has a son who is a CPA, and the son is the power of attorney and handles the dad's finances. But maybe the daughter is a doctor or nurse, and the daughter has a power of an agent for healthcare decision-making, so they're not necessarily the same. Now, sometimes I have seen law firms and attorneys who will work with patients and combine, a healthcare directive with other powers of attorney for finance. But so the key is you want to make sure you look at those documents and understand what they are. And consent, we've already talked about consent. How am I doing on time, by the way?
We started a little late, so about 10 minutes or so.
Okay. So consent, we've talked about informed consent. Implied consent is really if you go to an emergency room, or you're in a doctor's office. I mean, it's implied that you have consented to treatment in emergency room. So if you come in unconscious to emergency room, they're going to treat you regardless of someone signing off or saying it's okay. So and we went into detail about informed consent and refusal of care. Now, competency and capacity, I want to talk a little bit about that. Competency is a legal decision. And in Connecticut, it was interesting, when I was reading your statute, your statute used to have the word incompetent, but they changed it to incapacitated, which is correct, because competent is what a judge determines if you go before the judge. Unfortunately, my mother had early onset Alzheimer's in her 50s. My dad had died a couple years before. My mother had a boyfriend for a while that proceeded to revoke my power of attorney as she was in her progression of early onset Alzheimer's. So I was her power of attorney. She had many lucid moments. When she was lucid, I helped her do an advanced directive living will. But then her boyfriend had her revoke my power of attorney for finances and the healthcare power of attorney. So we actually had to go to court and get appointed, this was in Minnesota, so we were appointed what they call conservators over my mom's person and her finances, my sister and I. So competency is a legal decision. It's a very expensive thing to have to do. So please do encourage people to fill out the agents anyway. And capacity, though, is a fluid concept. So in Connecticut law, you will see that word incapacitated. If someone's incapacitated, then the living will, an agent for decision-making, takes effect. So normally, let's say you have this power, the living will and the agent, and I named you as my agent, and I went into surgery, I came out, and I was in a coma for 2 weeks. You would make my decisions for me. But I come out of the coma, I'm fine, I'm able to make my decisions again, then this is no longer active. This is only active in the event of incapacity. That's where all of you as practitioners come in. It's so important to talk to your patients, to really understand where your patients are in the progression of any kind of neurological impairment or confusion, dementia, AIDS, anything where they are going to, where their neurological capacity is compromised. And it waxes and wanes, and also someone can make a choice of what they want to eat for lunch, but they might not be able to understand that they have liver cancer and should they have chemotherapy. So too often, when I worked in the nursing facilities as an attorney, I'd get too many cases where the administrators would call me because the adult children demanded that mom be a vegetarian now after 10 years of eating meat in the nursing home. Now they wanted her to be a vegetarian. Well, we know that patient enjoyed meat, even though she was on a mechanical diet, she even ate food and meat, so, those are tough things because it's so easy to defer to that agent for healthcare decision-making, but you want to constantly be keeping that patient in mind and what is this patient's level of capacity and what is a reasoned decision. The other side of that, or I guess the same side of it is, I have a disabled brother who I was power of attorney for many years. Now he lives with my sister. And he'll be the first to tell you, he's a delightful man, but he's made poor decisions in his life. He has a brain injury, but he actually is, has a great deal of capacity and can make his own decisions. Now, whether they're wise decisions or good decisions, that doesn't matter. He can make a reasoned decision. So when someone tells you, like some of his nurses told me one time, you need to go get him declared incompetent so you can make his decisions for him. And I said, no, no judge in their right mind would declare him incompetent because he can make his decisions. He might not make good decisions all the time, but he can make those. So you want to keep that in mind. So as the agent, if you are the agent and you have talked to the patient and you know what they would have wanted, then you substitute their judgment. So you stand in their shoes when you make their decisions for them, if you know what they would have wanted. If you don't know what they would have wanted, but you do have some idea of their values, but regardless, even if you don't know what their values, you would do what's in their best interest. So the two standards there are substituted judgment and best interest when you are the agent or the healthcare representative. And best interest is very similar to being a parent for a child. So adults are considered competent unless or until proven by a court that you're not. It's the capacity that the clinicians determine. So let me see, I think I was gonna say one other thing about that. Oh, in some states, children will have the ability to make certain decisions at certain ages, depending on your state laws. So there are some, states, I think New Mexico's one, if someone's 14, they can make certain decisions. But, so children are, by definition, considered not competent to make their own decisions. We're not going to get into the case studies. I mean, I will be here after if you have questions, but you can use these. I think you have these slides. So maybe in your own clinics or in your classes, you know, these are just two examples. One is really based on my mother. The other is, Joyce had asked me to put one in about AIDS, but these are just questions to think about. These are the kinds of dilemmas you might come up against. You know, in particular, this one in AIDS, I think might come up more often than not, where a patient has chosen a partner as their agent, and maybe they're at the end dying, and their son or daughter come in the picture and don't agree with what the partner's decision was. You know, how do you deal with these things? So, there's a process, and I'm not going to go through this slide. I'm going to skip to the next one, but this is just the states that do have allow for lethal doses of medication when someone is terminally ill. So, and these are, again, things you should consider. Medical marijuana, end-of-life decisions for lethal doses, it's still against federal law, and no one who works at the Veterans Administration can participate in, you know, the medical marijuana or you know, any of these end of life because you'd be violating federal law. So again, these are things that you have to look at. And then you get into the ethical issues depending on your faith and employee beliefs and actions. But one of the strategies or the the things that can help you as practitioners, this Dr. Johnson has a great book. It's in an 8th edition, Clinical Ethics, and he calls it the 4-box method. So you have these 4 issues: medical issues, patient wishes, preferences, patient's quality of life, and outside issues. And if you have a case and there's conflict in how you personally as a clinician feel, or maybe among family members, you know, if you can get the stakeholders in a room together and even draw out the boxes, and of course you want the doctors there and the clinicians, and you write out the medical, what's the diagnosis, what's the prognosis, what's the current medical condition, you know, what are all the medical facts and the current treatments. What the other box would be patient preferences and wishes. And do you know what those are? If it's a surrogate or the agent, does that person know what they are? What was the patient's quality of life? Was this someone, you know, prior to falling down, getting a head injury? Was this person someone who walked 18 holes on the golf course every day? You know, what is the quality of life of the patient, not what you think is quality of life? And what are outside issues? Are there financial issues? Are there legal? Are there conflict and family issues? What are some of the other issues that you're dealing with or that have come into play with that person? But it's amazing how even if you don't agree, or even if family members don't agree, if you get people in the same room and you have a good facilitator and a good mediator or someone who's skilled at facilitating discussion to get everyone, very similar to ethics committees, although a lot of ethics committees don't actually invite the patients or the stakeholders there. But it's a similar process but facilitating discussion and making sure everyone's heard and gets to voice their opinion. It's amazing how much resolution you get with that. The other one experience I had that I will never forget, I mean, it was a patient who was on a ventilator, had dementia for many, many years, and she kept getting bouts of pneumonia coming in the hospital. And her son was her power of attorney. And the physicians were trying for many years to have her, you know, him consent to a DNR. And he finally did, and she was in the hospital on a ventilator, and they were removing the ventilator. And he really, the nurses and the physician group, I don't know that they did a good enough job of educating him on that process of extubation. Because in the middle of it, he started yelling, "Stop, put her back on." And so that, to me, I'm going to end with that because that was so profound. I was sitting out in the nurses' station, and I had worked, I was running the ethics committee at this small hospital, and I had him come to our ethics committee, and this is where we discussed this, and he agreed. And it didn't even dawn on me that, he really needs some education on what this is going to mean if he's going to sit here and watch it. So again, it's that keeping in mind as clinicians, the more we can educate our patients and the family members as to what we're doing, what's going to happen, the better off they are too. So I'm going to end with that. And thank you very much for coming out in the evening.
Thanks so much, Kathleen. Hopefully I've got a number of wheels turning, so you will have an opportunity to ask her questions. But I've asked my colleague, Dr. Donna Coletti, to come up and do a short response, and I'll give you a little bit of background on Donna. She is a hospice and palliative medicine specialist. She had coordinated the palliative care service at Greenwich Hospital for a long time, I'm not sure how many years. Recently left the hospital, but she's in private practice, and she is currently our scholar in residence for the Egan School of Nursing and Health Studies, specifically because she has this phenomenal background in palliative care. She also has the unique perspective of both the acute care side. Those of you who work in acute care settings know that you're the ones that are often facing this issue in an emergency type of way. The fact of the matter is the primary care side, the community-based care side, has to step up and also own this and help this process that Kathleen's done a great job of laying out for us. So I've asked Donna to come up and share some of her thoughts on that, and then chance for you to ask questions. Donna.
Thanks so much, Joyce. And thank you all, excuse me, for coming out tonight, and Kathleen for giving us such a really well-rounded presentation on an incredibly complex and often emotionally wrenching situation. And the example you gave at the end, I think, was perfect, because we've all been in that situation when there's a second victim and you haven't quite thought it through, and then you're looking at it and you feel powerless and you feel unprepared, and you realize this is going to have long-acting and rippling effect throughout the life of that person. And it teaches you for the next time, so you know you're not going to be caught short again on that. So I share that. And you've fleshed out so many really important scenarios, and for what many of you are going to face going forward. And what I'm hopeful for is that the palliative care curriculum here will start to give you these scenarios over the course of the undergraduate and the graduate curriculum to make you have a toe in the water experience, so that you don't end up in that position without a skill set, without, in some respects, having experienced and been prepared for being placed between sometimes the physician and the patient, or the physician and the family. So a couple of things you mentioned really triggered memories for me, and Barbara Leaf is in the back, and she and I have shared so many of these examples that I'm hoping to bring here for the undergraduate and the graduate curriculum. Some of which, you mentioned was the uninformed or unaware healthcare proxy. We had one where there was a father who showed up from California, hadn't seen his daughter in 10 years, and didn't even know he was the healthcare proxy. And she's intubated, unconscious, and 27 years old, right? And imagine him and the position he's in, and he refused. So people have the right of refusal of being a healthcare proxy. Then what do you do? Exactly what you said. You have to go to court, And you start this whole process of getting a conservator in Connecticut to represent the patient. But who really represents that patient best? Is it the conservator or is it her father? And is he emotionally prepared to deal with that? So those are all the ripple effect and the things you have to think about when you're put on the hot seat of this. The other thing you mentioned clearly was the difference between advanced directives and doctor's orders, right? Because so commonly, when I speak in the community, I'll have family members or patients say to me, oh, I don't have to worry about any of those things. I've got a living will, and nobody's going to do any of that to me. And so my question is, and where is that? Oh, it's in my lawyer's safe. Terrific. So that when you are on the line at CVS because you're having indigestion and you don't realize you're having an MI, right? And you go down, where is that form? Nobody knows, and most people don't even know you filled it out. But you paid $2,000 to get it done, right? Because people think of this as a legal document, when in fact, you know, it's really a medical document. And unless they're educated to that, you should see the faces of these people in the Jewish centers and the, you know, the Catholic and Christian post-service chats and coffees. They just look at you like you're crazy when you say, you know, that really has no bearing, unless you have it in your hand and someone that's with you knows what your wishes are. Because just as Kathleen pointed out, even if you have advanced directives that are filled out and you're wearing a bracelet, if you get brought into a tertiary care center and the person who's accompanying you is saying, oh, no, we were just talking about this morning. She doesn't want to have, she won't cut that bracelet off. She told me this morning she doesn't want anything to do with it. Well, do you think the doctor in the emergency room is going to argue that point? No. So guess what? The bracelet gets cut off and everything gets done. So these are the common scenarios we see every day. And it's not necessarily in the ivory tower of life in an academic institution what you come to experience. But then when you get placed in that position, it's a very rude awakening. So I really appreciate the scenarios that Kathleen spoke about, because it really is the front lines of what we deal with in the hospital. And you know, one of my hopes by being back in the community now is to be able to have these conversations in a much less threatening environment. Because when you're in the hospital, and whether it's in the emergency room, the ICU, or on the floor, people make decisions based on what I refer to as the evil trifecta: fear, guilt, and a lack of information, right? They're put on the spot. They don't know what the issues are. They're terrified they're going to make a bad decision or the wrong decision. Somebody's going to judge them. And so what do? Do everything. Do everything. Even though they know the patient wouldn't have wanted it. And it's because of their own sense of responsibility and fear of doing the wrong thing. So the more that we can have these conversations in a less threatening environment and educate people about really these common scenarios that they may very well be confronted with, the more you can clarify what their wishes would be and best serve both the patient and the family. And ultimately, the patient will pass. But there will be post-traumatic stress or complicated grief that will follow that person. And then that gets handed down to their kids, because they see the, you know, the consequences of bad decision-making or second-guessing. And it really is a ripple effect, which we can hope to head off by educating people about what they're really asking for when they're asking to fill out these forms.
And Donna has a good point in Connecticut, too. I mean, you don't need a lawyer to fill these out. In Connecticut, you need 2 witnesses, and you don't even need it notarized. So, I mean, you can do this anytime, and thank you for bringing that point up, because I forgot to say it. I mean, you really do need to bring those into your physicians, but you don't need the witness. You can get the witness to attest to, you can get the witness to attest to a notary, and then there would not, if there was ever any question on whether that person was a witness, you'd have that taken care of. And the other thing is, when Donna was talking, I was thinking about the term withholding and withdrawing treatment. As a physician, you probably know better than most, but there's a psychological difference for many family members and healthcare representatives on withholding or withdrawing. There's no difference under the law, but if you talk about with not even putting a feeding tube in versus stopping one that's already in, there again, you're going to need to get into more conversations and have, really hold the hand on these, for these people. And I'm just going to say there is an epilogue to that case I ended with. That woman went back on the ventilator, and I mean, this was someone who had no she was, totally end stage in her dementia from a neurological mental standpoint. She went back, she eventually weaned off the ventilator. Weeks later, went back home with her son. Home health agency found the son at home dead of a heart attack. So they ended up having to go to court to get a guardian, and the guardian did not make her a DNR.
There we are.
Anyway, horrible story.
Mm-hmm.
Thank you. And actually, if you can come up too, because either of you can answer questions as long as it's in the mic. And I have to ask you all, if you have a question, to use the mic so we can catch the question on it. So who has something they'd like to ask our experts here?
Hi, my name is Gina Travato. I am a nurse at Greenwich Hospital, and I also work here as a lab coordinator and faculty. My question is related to a clinical encounter that I had at the hospital, and sorry to the Greenwich people here who have heard the story many times because I'm still not over it clearly, but I had a patient admitted for uncontrolled AFib, and long story short, had an embolic stroke as a result, and wound up in a comatose state. On admission, he handed me his advance directive stating he did not want advanced measures, life-sustaining measures. And he wound up passing away on BiPAP with a feeding tube in his nose, and it completely went against what he stated in his document. So my question for you is, what is more powerful, a written advance directive or a healthcare proxy?
I think you stumped them.
Yeah, I'll take it.
Go ahead.
So the healthcare proxy, as I've mentioned, people can decline because they don't have to be told that they are the healthcare proxy, right? So they always have the escape hatch of just saying no. With regard to the advance directives, you and I know those are just guidelines, right? They're not doctor's orders. And we know they sidestep doctor's orders. So the guidelines can easily just get pushed aside as well. I think the best thing, the most protective thing anyone can do is get a doctor's order. And, quite honestly, many times in the hospital setting and outside, I've had to explain to doctors the difference between healthcare proxy and advance directive and post or most. That physicians don't even recognize what the distinction between these things are. And they often think that the patient has to go to an attorney to get it filled out. So these are all really common misperceptions. And unfortunately, at the bedside in the hospital, that decisions are made because of concerns that the wrong decision will be made. So people will always err on, okay, let them second guess me, but at least I did what I thought was the best thing at the time, because no one's going to come in and say, well, you didn't even try feeding him. And, although verbally it went against, his wishes, and if the advance directives, once again, they're guidelines, they're not doctor's orders. And if you had a doctor's order, that would have at least superseded it. Does that somewhat answer it?
I'm not sure I was clear on the facts. This was someone who had been in a chronic state and had a acute episode and ended up back in the hospital, and he had had discussions with people and had done his healthcare directive.
His brother signed the document, and his brother was the proxy that he handed to us. It was a legal document. But he had chronic AFib, which resulted in an acute event that turned into from what it appeared to be a comatose state.
I see.
So it was very complicated.
What was there was the time period, like within 24 hours that this happened, or was it?
I think it was within 2 days of admission. He wound up with the CVA, and then I think lived for 2 weeks following, where decisions had to be made on his behalf. But I think for nurses caring for him, and I would think that the medical staff, the residents and interns taking care of him, it just felt disillusioning and unethical to see and read his advanced directives in the chart and then not have the orders reflect that. And it felt like we were doing illegal things for him and also unethical things for him. And also, it was frustrating to know or to not have this kind of move kind of more in the patient's favor when he clearly had his wishes delineated very clearly.
And it sounds like there was a 2-week period then where this was going on. So did anyone call an ethics consult or try to, did you facilitate, was discussion facilitated on this issue then? And what was?
So I think, sorry, I should just hold this.
Maybe we don't want this piece of the recording to be recorded, I don't know, with cases.
Should I answer? Okay, I don't know.
I mean, I was just thinking that.
If we could, there's probably more specifics that we shouldn't go into, but if you can address the general question of.
Yeah, I think that, I mean, I agree with Dr. Coletti on, some of the things she was saying about the scenario. I do think, though, that, I mean, it is a document that, can be legally binding depending on the circumstances. But, I mean, you do need the doctors to cooperate and look at that and work and write the orders. I mean, you can't just stop things if the doctor has written orders. But I think it is an issue for an ethics committee if there's that much conflict in, I mean, it sounds like there was a conflict in what his written wishes were than what was done, and without being there and knowing all the facts. But to me, especially with that kind of time frame, of more than 24 or 48 hours, I would say, I would hope that an ethics consult with some skilled facilitators would have helped resolve that and really work with that. And if the healthcare proxy was there, the brother, you said he was involved.
He was involved over the phone, so he lived across the country. I can't remember which state. It seems like it's always California, but he lived in California.
Okay, and he was okay with the doctors doing everything, or he specifically said do everything?
So I worked a night shift, so I wasn't there for those conversations.
Yeah,
so
okay.
I can't really speak to how involved he truly was, but I think the moral of the story is to just maybe he never had a conversation with him about, maybe the patient never had a conversation with his loved one and had him sign this document, maybe never was very specific about his wishes. So I have to also think of that as an alternative.
Yeah, I mean, I think there's too many facts, but that's where if you get an ethics consult with a skilled facilitator and bring that healthcare proxy or agent in on that call, even as a conference call, you can get some answers. Things will often fall out. I mean, I really believe that, and I don't think that we do that enough.
And I'll just add one more thing, goes to what I said earlier. The more discussions that the patient themselves can have with their loved ones, their healthcare proxy, whoever, being clear before they're obviously at a point where they're incapacitated, that removes some of the question for them, but also might help the patient understand that, oh, you know what, my brother, I thought he was going to be sort of more on my side, so to speak, understand my wishes, but maybe the brother's not really comfortable with making those decisions, but without having had more thorough discussion before they're at the crisis stage, that doesn't happen. Another reason why it has to start with primary care providers in the community when patients have conditions that are going to put them at risk. They're not perhaps going to die today, but that they need to plan for times when that might happen, especially if you haven't, all of us need it, but especially.
Well, and that was the other point I wanted to make. Diana and I were talking about it earlier. Back in the day when I got out of nursing school, I mean, you know, we saw physicians, my family physician, you know, was everyone in my family. He followed us for years, and when my parents were in the hospital, he came to the hospital. He was the attending. He made the decisions. They knew us. The doctors knew us. Nowadays, you have this disconnect with the clinics and the acute care physicians, the hospitalists, the attendings, who end up with these crises. And that's the sad thing, because the clinics, in fact, we talked about that today, both of the sessions we had today, I said, how many of you actually have visited your patients in the hospital when they've had bouts in the hospital? Or how many, you know, nobody. That's just not how it is. So it's even more important to work for the clinicians in clinics and the people who are seeing those patients while they're well and before their disease progresses, to have these conversations, talk to them about who is your agent, does he know? I mean, these are things that we can help with so that we don't end up in these crisis situations and put all of that responsibility and the burden and the grief on what we call second victims, you know, our practitioners in the hospital. So.
Yeah, and you know, Gina, with regard to what Kathleen said earlier, that people suspend their DNR for surgery, you know, we see that all the time. Advanced directives aren't even orders, right? They're just guidelines. So I know I keep coming back to that, but that's what's really, I think, the linchpin point of this story, is that you just had guidelines to go by. And as per what Kathleen said, that in this era of a lack of trust, right, that the person who's making the decision really doesn't know this guy. His brother really doesn't know them. There is no trust there. And so, you know, how do we establish trust? And it's by having multiple conversations with people that we know over time. And that will hopefully lessen the impact of these kind of, and the frequency of these kind of situations. But, you know, we've also talked many times about the imprimatur of God going in the room. If you can get one of the clergy to get involved in these conversations, that often diffuses the whole mistrust, right? So if there was ever an opportunity through the ethics committee, you know, to have a person's clergy be involved, even if they are in California, you know, on a three-way phone call, that at least, you know, gives some credulity that you're paying attention to things that are more than just the medical side of it.
And I don't know, I mean, I'm not sure that I totally agree that they're guidelines, because they are a directive. It's me telling you this is what I want. Now, a physician or a provider can look at it as a guideline, but again, we went through this whole thing on autonomy and you know, and my right to make my own decisions in advance of where this condition I may be in. So I think they are stronger than guidelines in some ways, but I mean they aren't. I don't know that I would call them that. But it is the practitioners who have to write the orders pursuant to those guidelines. And if there's discomfort for whatever reason, very valid reasons, that's when I think that's when you need to engage in discussion. Why is there discomfort with this when this patient clearly looks like this is clear what they want? I mean, what is it about the medical indications in this case, or the, you know, something with the agent's preferences? Is that agent standing in this patient's shoes? I mean, what are the issues? And talking about that, some of these can fall out. But, I mean, that's how I,
Right, so
look at
it's a
So
language thing, right?
Yes,
We
yeah,
have
exactly,
laws,
exactly.
we have orders.
Yes,
And then we
yeah.
have this gray zone that it's not
Yeah.
a law, it's not an order.
Right,
it's somewhere in between.
It's a patient's directive.
That's right.
And what do you do with that? But I would say for me, it's more than a guideline, it's my directive. And what you do with that as practitioners in context with everything, though. I mean, that's the thing. I mean, I think what Dr. Coletti is saying, you can't operate in a vacuum with just this piece of paper. How does it apply? And how does this person fit in? But, okay.
So I had sort of the opposite thing happen many moons ago, 30 years ago. I was a brand new nurse working on pediatrics, and there was a baby on PD that had no parents in the picture, had some, I forget what the anomaly was, but there was brain damage and periods of apnea and a feeding tube, and was basically there to die. We were going to transfer him at some point, but in the meantime, he was a DNR. There were orders for DNR. And yet, we were tube feeding, I don't, whatever. But what happened was the orders were for a DNR. And this is that legal ethical dilemma that you brought up at the beginning. And I've been wondering for all these years, what is the legal ramifications? The baby stopped breathing and basically died one night on night shift. And the nurse, although we were just all hoping that the poor baby would not be suffering anymore, she couldn't. Her values were such that she couldn't not do CPR, and she resuscitated the baby. And I mean, we were all astounded that when she reported that to us in the morning, I mean, nobody would have known other than she told us all in report. And I don't know that, I'm sure no ethics committee, this is 30 years ago, nothing was done. I don't even know if she documented it, to be honest. But I've always wondered, like, wow, what does that do to her risk of her license at the time? And is it a legal issue? Could she have been, I don't know. I just wondered your thoughts.
There was a DNR?
Yes.
Well, 30 years ago, nobody was looking as closely as they are now. And things were always just dealt with in-house. So, if anybody disagreed with her, then she would have been, reprimanded in that way. It's unlikely that it would have gotten outside the hospital.
Yeah.
I think things were just dealt with very privately, and especially because if they knew her and they knew what her religious fundamentals were, and, then you're challenging that. And nobody wants to get into the newspapers about that.
Right.
So I think so much in the past, and not for bad reasons, was dealt with privately within the hospital and within the hospital's own ethics committee and spiritual care department. I think a lot of that.
The fact that the baby had no parents was the big difference.
Well, and that was, so that would have been in the 80s?
And I was only 4 years old.
But no, remember, how many of you, see, you're probably too young, but I worked at Children's Hospital in Seattle in the mid-'80s in the NICU. I mean, I was a float nurse. And there were signs out, the baby doe cases, and it was very much, the neonates, I mean, it was tough. It was much more, pro taking care of these babies as opposed to actually having a DNR order.
Yeah.
So that's more surprising to me that there was one, and because the nurse violated, that could have been like a legal issue because she violated it, but.
But that's only if somebody wants to bring it.
Exactly. But those, I mean, that is what I would agree with what you're saying, and they handled it internally because I think during that time period, it was much more, it might have been looked at, why was there DNR?
Sure.
As opposed to there was and she violated it.
Thank you.
Other questions? No, you're all tired.
This is really, I mean, this is at least a half a day or a day.
Oh,
I mean,
absolutely.
I covered so many things. I hope I didn't confuse people because it just went
No.
through so many different.
So one last question for the evening, and then as she said, if you have things you'd like to just talk to her about, she'll hang out for a little bit.
Thank you for answering my first question. I really appreciate that. I have a little list here, so I'll ask my most important question next to my first one. But what are your thoughts on assessing the capacity of healthcare proxies?
Okay, well, so if we're starting with the patient, right? I mean, so I know you're asking about the healthcare proxy, but just back up just 1 second, because Kathleen brought this out in her talk, which I think was really important, that people have limited capacities for healthcare decision-making. And, you don't have to be a psychiatrist to say that this person lacks the capacity for healthcare decision-making. I want everybody to understand that. Any physician can make that determination. It doesn't have to be a psychiatrist. So with regard to then the healthcare proxy, I think the same thing applies, right? You can say this person may have, accomplished X, Y, or Z, knows the president and everything else, but they're medically illiterate. And so they don't have the capacity to make that decision. And I think if you can give a documentation as to how that person exhibited the behavior that makes you question their medical literacy, I think then that's what you can stand by, the same way you could stand by it for a patient.
Or you could try educating them and sitting down with them and educating them on these decisions. There's a lot of patients aren't educated either on medical decisions, and they're relying on us to educate them. And I think it's similar with proxies. But there is literature. I mean, there are proxies, you can question the capacity of an agent for sure. That's.
Thank you. That's news to me.
Thank you all so much. Have a good evening, and if you want to speak to either of our speakers, come on up afterwards.